And this is going to be our sort of a bit of a civics lesson, so bear with me a little. One of the big thing is, so lawmaking process is pretty slow, and it's very convoluted. And cybersecurity threats arise quickly. So we have this, the law as a tool takes a while, and by the time the law gets around, the risks have moved on. And that becomes, and that's why it's such a challenge sometimes to find a law that applies, that's currently available, that applies to the situation. So, bear with me. Under the US Constitution, we've got 3 branches of government. This is the civics review. Congress makes the law, President enforces the law, courts interpret. So that's, balance of powers. But how the laws are made actually is a serial process as well. And I think that this is where it's part of why it's so slow. So you've got Congress, legislative body, makes statutory law. And then agencies, the administrative branch, regulatory law. And the courts then judicial interpret law. So I'm kind of giving you the vocabulary, but basically it starts with Congress. They pass a law. There's what's called an authorizing statute that allows the regulatory agency to pass regulations. And then through that enforcement comes a case or controversy, which is out of the Constitution, that creates a judicial case. One of the questions that prompted this presentation was why we've got all these bills in Congress. What's the story? And so I kind of wanted to do this discussion. It's going to be somewhat abridged, just because the process is sort of the song from Schoolhouse Rock about how a bill becomes a law. What I did was I looked at cyber, asterisk, in the current congressional session. And there were approximately 500 laws. This was about 3 weeks ago that I did this search, and there have been a couple of new bills that have been proposed. So there were 500 bills that were proposed. And it's basically any lawmaker can come up and say, there ought to be a law on botnets or whatever. And what happens is those bills get sent to committee. And there are different committees around Congress to focus on topics. And they have hearings, they do reports, and at the end of their discussion about it, the bills, they come to a vote and they basically say, this is what we're putting forward. Out of 500, about a quarter make it out of committee. From that, it goes to a full floor vote, and it's about 20%. So then what happens is, after the House votes, it goes to the Senate. It goes through the same process, committees, reviews. And you end up with about a fourth, about 25%. So you go from 500 down to about 25 laws that come out of the Senate. And then if the Senate and House laws don't quite line up, they'll go through a process called reconciliation. And then you end up with they vote again, it goes to the president to sign. So out of 500 bills, there have been 19 laws that have something to do with cyber. Most of these laws are funding existing programs. They are kind of inside baseball, like the Congress will tell NIST to do something, or Congress will authorize the reorganization of the Department of Homeland Security. It's not going to affect the cybersecurity law landscape as much as it's going to affect the operation of the government itself. So the key element of this, and sort of the why are there some of these bills and what happens with the law, is many bills are proposed but very few become law. So if I were to advise you what to watch as they discuss the different bills, but only care about what gets signed by the president, because those are the only ones that are laws. And so it's a really small amount. Yes?
So compared to other areas of legislation, would you say the cybersecurity area is active or not as active? Because I hear a lot of discussion that the folks in Congress really don't understand technical issues as well. So I've always wondered if, if they really engage in trying to make more legislation around these areas.
So I would say sort of Congress reacts to what's kind of in the media and kind of in the public discussion. They take what they get from their constituents. They also, it's a very political environment and very polarizing environment. So it kind of depends a little bit on sort of what is being talked about. Do they understand it? No, they still don't. As evidenced by the Facebook interviews. But one of the things that's really challenging is you have different levels of expertise, and their staffs have different levels of expertise. So I'm an odd lawyer because I understand the law and I understand technology, but a lot of lawyers don't. And it can be challenging because lawyers that then go into politics and begin run, they may or may not understand it as well. So from the standpoint of, is there a lot of legislation? In a given congressional session, there's about 5,000 pieces of legislation that bills that are proposed. Approximately, maybe about 1,000 in the Senate. Of those, maybe a little more. If you say 500, we're getting close to the end of a congressional session. So maybe a tenth have some kind of cyber. It's not unsubstantial, but it's not huge. A lot of what the government does is based on, it passes bills to fund programs that are going on, ongoing programs, new programs. So there's a lot of funding. And so then the question comes down to, for cybersecurity, a lot of it's tacked on to other pieces of legislation, like defense authorization. Defense authorization is the funding mechanism for the military. But what happens is, in that large bill, there are all these little requirements for little things that are kind of sideline issues, small acts that get added. And so that's part of the committee process where they start to tack on legislation that they want to get passed. And so if they tack it onto a military funding bill, you're going to have political fallout if you vote against it. So, yes.
Yeah, to make up for the lack of technical background for members of Congress, should we bring back former Office of Technology Assessment after DOT was eliminated?
I think that maybe. I think a lot of it depends on not having the office, but how they use it and how they have access to information about it. You're dealing with, you're dealing with folks who may be older. As I get older, they're less older, but you're still dealing with people who technology was not their forte to begin with. So whether or not how policy gets made, how good laws get made, is driven much more by how well they listen than necessarily whether it's a particular office or how they, how they structure it.
I don't think those 19 laws that you're talking of is not the real problem, because whether they understand or not. But then it goes to what you call regulatory guidelines. And that's where the problem, in my opinion, is, because For example, if you receive a fraud check, and it's happened to me 2 or 3 times, more than that, then I said, what's my option? FBI has a website. You go there and you fill out a form and send them all the records and everything as attachment. Nothing, you just get an acknowledgement receipt that we're looking into it. Then you file a second one. So, and then after a year, there's nothing. That means the regulatory process that is with FBI, they think these are minor things. Ignore them. And that's what happens with these laws.
It can. It can. So I'm going to kind of cover the regulatory process a little bit. What I wanted you to know from the regulatory process is it's a similar sort of stages. And you end up with Federal Register is the paper record for government agencies. And so the process to create a new regulation, the agencies themselves, every 6 months, publish their intentions in the Unified Agenda. And it's a huge set of documents, and it's done by agency, and you can look. And some of those
And
unified...
budget too.
Huh?
How much money they have to do what.
True. And it also depends, there's some political things. There's also items on the Unified Agenda that have been on there for a decade that just keep rolling every 6 months. So the first thing that really happens is they'll pull one of their projects and they'll do a notice of proposed rulemaking. And that'll go in the Federal Register and they'll say, hey, we're thinking about a regulation. Give us feedback. Then there'll be a notice and comment period. And then the agency will take those notice and comments and issue a final rule, generally answering the questions in aggregate as part of the final rule. So there are sub-steps within the process, and the numbers vary depending on the issue, so I couldn't do a numerical analysis. It depends a lot on the comments. And what I'll tell you is the comments from the public can really affect the regulation. So I have seen regulations, the notice will come out and I'll participate, I'll write a letter or something, and it'll be 20 or 30 comments or 100 comments. And that's something an agency can process. I've also seen it where it's 10,000 comments and the agency gets overwhelmed and they can't go through all of those comments even in aggregate. And they'll give up on the regulation. The key thing, only the final rules matter, and only after their effective date. So you'll see a lot of this comes up, and there's this new regulation. And if it's not effective for 2 years, and the idea is that there's going to be an implementation timeline. But it's sometimes they're quite quick, sometimes they're not. Judicial process. In order to sue, you need a case for controversy, you need to have standing. And so that's kind of a key thing. And so there are 3 levels of review. You have a district court, a court of appeals, and a Supreme Court. And this is how it works for the federal system. And you start at the district court, and then you appeal and appeal. And then it also applies to state courts. Although the state court, you can apply, if the state Supreme Court has heard a case, it can go to the U.S. Supreme Court. An example, a lot of the criminal cases, Miranda v. Arizona was, so the case that established Miranda rights in a criminal investigation, right to remain silent, all of that, that was a state law case that got appealed to the Supreme Court, the U.S. Supreme Court. It did kind of the same sort of thumbnail analysis. Most cases get handled at the district court level. A smaller number, about a third, go to the Court of Appeals, and then a smaller fraction go to the Supreme Court. This is actually kind of surprising, but this is just kind of a broad search on cyber.
Since you're talking about courts, can you sue a federal agency in a state or a district, like in DC? Can you sue them in a DC court, or you have to go to the federal court? Just,
You
I
have to
an
go
issue
to
with-
federal court.
You have to go to federal court.
Because you're suing them based on a law. And so whatever the law they violated, that's going to be the jurisdiction of the suit. And
If
then
it is a tort case against CPB, let's say Customs and Border Protection,
Mhm.
so do you have to go to a federal court or just a small claims court if the amount is a small amount, like $1,000?
Okay, so the answer to the question is generally, kind of depends. You may have to go through, there's a regulatory process. You may have to go through an administrative court.
Yeah, they have a regulatory process.
Yeah.
After you exhaust that, then they say you have to go to the federal court.
Yes, and that's
Is
true.
that
Because
how-
because when you're dealing with a federal agency, you're dealing with federal law. And so it's the case, basically you would, even if you brought it to a state court, the state court would.
We'll throw it out.
Yeah. So the key thing with the court cases is that the case only applies in that jurisdiction. So you can have a situation where in one circuit, the one region of the country, the law works one way, and another circuit, another region of the country, the law works another. It's called a circuit split. And those are the kinds of cases that go to the Supreme Court because they really you want to have some kind of uniformity in the law. All right, so to kind of to sort of tie this all together, lawmaking is a slow process. The legislative cycle is every 2 years. And so when the new Congress comes in, they start over with those bills, those hundreds of bills that haven't been addressed, they go away and you start over. Regulatory 4 to 8 year cycle based on the administration that comes in. And so when the new administration comes in, they start over. They may change what's in the unified agenda. Judicial, 6 to 15 years, roughly. Each case can take months or years to be decided at each level. There's all these twists and turns in a legal case, that different motions and different steps in a trial. So it's a very, very slow process. So I'm going to say, estimate of 10 to 20 years in total to go through that whole process. And it's very political. And so you have these political shifts that will affect the process of a case or process of a law. So the law is not all powerful, it's imperfect. It looks backward, it's limited, it's slow to change. And when you think about technology applies broadly. It looks forward, and it's very quick to change. And so this dichotomy between the law and how it works and technology creates a lot of tension between the two communities. And that's a lot of why you have lawyers who don't understand technology, is because a lot of what we're trained to do is to look backwards at what has already happened. All right, so this is the fun section for me in terms of talking about the future. And so I'm going to do a little theory, and this is kind of my theory of how the future of cybersecurity law works. And then I've got some slides on what's new, what's happened in 2018 that's new, and where I think things might go. So, where do we begin? In order to understand the future of cybersecurity law, you have to look at kind of these technology, business, and law as agents of change. And as I said, technology changes quickly and law slowly. There's actually two lags that I want to point out. Suppose we look at technology changes quickly, and Moore's law, data capacity doubles every 18 months, roughly. I'm going to apply this as a thumbnail to technology change more broadly. So just suppose that for a minute. Then with business, it takes about 5 to 10 years to start a new business and get it off the ground. So things like, okay, well, I've got this technology, I need a minimum viable product, I've got to get investors, and you've got to kind of get a beta product out. So this is my thumbnail estimate. And then as we talked about law from the previous section, 10 to 20 years. So if you were to start the changes simultaneously, law would lag behind. But the change is also serial, because you have to have a technology that then creates a business, and then have a legal issue. And so this cybersecurity law development lags far behind technology. So when you ask sort of what the lawmakers are looking at, they're looking at stuff that's several iterations back in terms of, well, we've heard about this, you know, I remember the internet being a series of tubes, and now we have the Facebook, and, you know, really not understanding social media. That's in part because of this sort of serialized change. So this is kind of the big picture slide that I want you to sort of take in. Technology, between technology and business is an idea of what you can monetize or commercialize, right? So I've got this technology, how do I make money with it? How do I make a lot of money with it? Because there's the payoff, the investor payoff. And so the key is what's scale. But after that, once you have a business that's scaled, you have these risks and problems that arise. And it's what problems arise from scaling that businesses can't solve with technology. They are, these are the surprises. And that's where the future of cybersecurity law resides, is how do you address these surprises? So to use an old example so email, RFC 822, format of an internet message, near and dear to my heart as a former spam fighter. 1980 was when that was written. ISPs figured out how to monetize email as a service in the 1990s. Fairly quickly afterward, spam came about. That was the surprise. And then canned spam. So the idea is sort of, this is how I see the progress. We've got time. So that's really kind of how I look at it. So when I look for where things are going to be, what's new in cybersecurity law, it's going to be in that surprise category. All right, so I'm going to talk a little bit about new laws to know. What's happened in this. This is mostly 2018 law. And I'm going to go through by jurisdiction. I will warn you ahead of time, there's a lot of words on the slides. So I wrote them, and I am going to provide the slides so that you can post them afterwards and have access to them. So just kind of bear with me. I'm going to cover the highlights. And we'll kind of start. So I'm going to start with California. My supposition, and I'm actually going to write an article for the ISSA Journal on this, for their February issue. California is pushing the federal envelope. And so they passed what an Internet of Things law. And one of the things they said was, okay, manufacturers who make connected devices shall implement reasonable security features. Now, manufacturers, not distributors, not vendors. Connected devices has an IP address or Bluetooth. And then reasonable security features based on the nature of the device. It's all it says. It's a two-page law. But it's stark. So if you talk about IoT and insecurity, then California is progressive. It tends to embrace change first and push the needle. So that's what's happening.
Sorry, as manufacturer, would that be Apple or would it be Foxconn?
The law says manufacturer, that's all it says. Now, what it would likely be is OEM, so Apple, and likely based on who is kind of the, like in that OEM model, it's like who is selling those. And really who has jurisdiction in the US or in California in this case.
Some of the things that make me think about are that California is cutting edge technology.
Right.
But you can't fix a broken protocol with the law necessarily.
No.
But you can dictate that a manufacturer do things like encrypt and put in safety features that would prevent the device from authenticating.
Yes. So this is a first step. It says reasonable security feature. That's what the law says. And so then the question will be, in this is an ongoing conversation. So then, laws passed, we'll see what happens. There will be the California AG will pick a prime example of a manufacturer that's not doing anything with their devices, has had problems, and they will take them to task. Then it will likely go to court, and the courts will then start to interpret what reasonable security feature means. Reasonable from a legal standpoint is usually what we call it an objective person standard. So it's not, they're gonna interview an information security professional to find out what reasonable is and whether or not what security was implemented was in fact reasonable. So that's why I mention it, because it's a good first start. And it certainly is, it's an initial discussion. It's not the end of it. California Consumer Privacy Act, California passed a GDPR-like law, and it comes into effect in January 1st, 2020. So what's really interesting about it is the law explicitly references the Cambridge Analytica issues, Facebook being in California. And so if you notice, Cambridge Analytica, Facebook in California, and the law comes into effect 10 months before the next election. There is a certain implied political discussion happening there. What I say about it is all technology roads lead to California. So a lot of tech companies are there. California is a state with 40 million residents. Most of them are very tech savvy, higher tech savvy populace. So anything that, any service, any device that's going to process California information is going to be subject to the act. It's going to force the discussion more nationally about privacy, overall consumer privacy. Net neutrality, if the privacy law was kind of an inferred political discussion, this was kind of explicit. California passed a net neutrality law to address lawful internet traffic on fixed and mobile internet service providers. Basically, the federal government has gone through the 180-degree change from Obama administration net neutrality regulations to Trump administration, they're calling it open, restoring free internet. So, huge debate, very polarized, and California has passed this law to kind of make their sentiments known. And so it's definitely an inferred political fight between California and the US government. Because of California's role in technology, the idea is that it's a temporary stay until the court systems figure it out. But what this will do is tell internet service providers that that operate in California, and a lot of them do, kind of hold off implementing the net neutrality, the new FCC regs. Supreme Court, there's really only one case that I thought was really worth talking about, but I'm gonna mention two, because it came up actually in the Mid-Atlantic Conference, and I was interested about it. So, Carpenter. Basic case. Carpenter was he was being tracked by law enforcement over a long period of time. And they pulled his cell records. And the court ruled that law enforcement needs a warrant for this kind of cell location data. What I wanted to highlight is it was 13,000 data points over 127 days. And so that's more than 100 data points per day. Think about how much you may travel in a day. That kind of data is a pretty good idea of what every place he went. So then the question the court really looked at is, do you have a reasonable expectation of privacy with your cell phone location? Your cell phone then becomes a homing device and an electronic tracker in your pocket. So that's why the court ruled that they need a warrant. And the reason why I point this out is that when we talked about surveillance and the law enforcement looking at individuals as criminals, there's a whole branch of law dealing with the Fourth Amendment, search and seizure, and what requires a warrant. And so this whole idea of new technology, every time there's a new technology, we have to go through this process of, do you need a warrant or not? And so this is where there will always be some discussion. So Carpenter was probably the biggest case that came out. There were some other privacy cases. Care First was not a Supreme Court case. There was a lower court case, and it appealed to the Supreme Court, and the court denied certiorari, which means that they appealed, and the Supreme Court said, no, we're not going to listen to this. What that means is the lower court ruling stands. It's not affirmed by the Supreme Court. It basically was sort of said, that's fine. So the case actually involved a health insurance company. They were subject to a data breach, and their insurees sued them and won. And what the court held is that damages could be awarded for the threat of future identity. So, company had a breach. The insuree's data was affected. Nothing happened yet. No identity theft yet. But the court held that it was so probable, and there was no other reason a hacker would hack into a system, that